Welcome to the Appellate Division. We have almost 7 hours of argument time requested today, so only ask for the time that you need, not the time that you wish. We are familiar with the briefs and the records, and we will keep asking questions if we have them. People versus Melendez is submitted. Elfond versus Adams, appellant. Okay, the appellant is not here. Do you wish to submit? I think we're all good with submission. Okay, the case is submitted. M. Jarrell is submitted. Tishman versus Himmel Merengoff is withdrawn. Rondon versus 328 West 44th Street, appellant. Respondent? 5, 2, and 4. 470 4th Avenue Fee versus Wesco Insurance, appellant. Respondent? 5, 2, and 6. People versus Vinant, appellant. Respondent? 4, 1, and 4. Healy versus Trinity Hudson, appellant. I'm sorry, respondent what? 5, 2, and 5. Doe versus Yeshiva University is submitted. Ink Mango versus Warren, appellant. Respondent? 6, 1, and 6. And again, if we have more questions, we'll keep asking. Christian versus New York City Department of Education, appellant. Are you respondent? Do you wish to submit or? We'll have it submitted. Quash versus CNA Jerome Realty, appellant. Respondent? 3, 2, and 3. Katz Wisnadel versus Lower Manhattan Dialysis, appellant. Nobody wants to argue today. Submitted. Molina versus Chatham Towers, appellant. 5 and 2, please, Your Honor. Respondent? 5, 2, and 4. People versus McBride, submitted. Lash versus Modular Holdings, appellant.
5 and 2, please, Your Honor.
Respondent? 5, 2, and 4. U.S. Bank Trust versus Santiago is submitted, and Sire Spirits versus Beam Suntory is submitted. So our first case today is Rondon versus 328 West 44th.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. My argument is kind of simple, so let me just get right to it. I think this case is governed principally by the Kelman decision in the Court of Appeals. I cannot see a functional difference between this case and that case. The argument of my esteemed adversary that the Rivera case overruled Kelman sub silentio just doesn't really make a lot of sense to me. I don't think the Court of Appeals would overrule a precedent without citing to it, and I would just add to you, if you look at the Court of Appeals decisions, I came down in San Miguel just this week, and you look at the decision that overruled the strict liability in tort with regard to domestic animals. Court of Appeals spoke extensively about stare decisis. So to me, I can't see a functional difference between this and the Kelman decision. The Rivera decision that they cite, I don't think applies to this case. It was a Court of Appeals decision, but if you read the decision, I believe Judge Smith's basic purpose there was to talk about what is the responsibility of a landlord versus a tenant with regard to making changes in the premises. And if you read the decision, specifically the last 3 paragraphs of it, Judge Smith is very careful to talk about the fact that in that case, the plaintiff didn't even claim that the radiator was defective. The plaintiff's claim was that the radiator was defective because there was a child there. And he said that the cost of that should be borne by the tenant, not by the landlord. That's not this case at all. We have undisputable evidence from the photographs and from the video that you all saw. There's 12 inches between the sill.
So can I ask you,
Of course.
Mr. Isaac, so your position is even if there was not a violation of a code of the, if a code that applies, that we could still find negligence here?
Yes, that is
And
exactly my position.
so I guess the question then is, how do you distinguish that from the hot radiator case where the Court of Appeals says, well, there's nothing to prevent the hot radiator, there's no code violation, so in that instance, there's no common law duty or violation of a common law duty?
Right, and that's what I was trying to say, Judge
Right.
Capullo. I'm sorry, maybe I wasn't.
No, I know you said it, but I kind of didn't understand what the difference is.
Yeah, so
Right.
let me try to convince you. In the Rivera case, when you read the decision, the plaintiff in that case specifically said that a radiator itself was not a defective condition standing alone. The defective condition was the radiator caused by the fact that there was a young child there. And I think what the Court of Appeals said there is in that situation, the cost shouldn't be borne by the landlord. The landlord doesn't have to put things on. That's a situation that's borne by the tenant. The tenant can put a radiator cover on it if he or she wants. If he doesn't want to, he or she doesn't have to. In this case, our claim is that the opening, the unguarded opening, which is exactly the same as Kelman, was a defective condition that had to be guarded. This was not safe for anyone, whether it's an adult.
Do you want to talk about the violations of regulations as opposed to a common law duty?
Sure. So,
Why those are viable claims?
and I think there are 3 cases that I'd like you to take a look at. I know how intently you view the cases, but if you look at the Powers decision, both your decision and the Court of Appeals decision with respect to it, the Pappalardo decision and the Kupchak decision, my expert, he went through the building code and the various, I guess, governmental agencies' provisions extensively. He couldn't find that much because it's a 1906 building, and you saw the 96 pages that he had. They had little writings and little drawings. They don't do that anymore. I think what those cases stand for is that the burden of proving non-applicability of a building code regulation or a similar kind of regulation in a summary judgment motion is borne by the movant.
So what evidence is there about the applicability of the 1968?
So you have 3 separate situations where the building was changed. You have a 1937 violation, as you know, on the fire escape for rusting. I know we're not talking about rusting.
Yeah, this is
That was
not a
violation.
rusting case.
That's right.
There's nothing to do
But we
with
have
this.
5
You're
other.
not suggesting that if there's a 1937 violation because the fire escape is rusting, the 2006 code no longer applies?
I would hope, Judge Friedman, I wouldn't say that because that's insanity. That's not what I'm saying.
Even as
What
to
I'm-
the later violations.
Right, but there are.
What's the significance that they refer to the 68 code? Is that evidence that the 68 code applies by itself?
It could be, in the context of a summary judgment motion, the answer to that is yes. I think if you look at.
In what way? I mean, isn't it a matter of law whether the code applies or not? Does it change depending on whether some person's writing out a violation and messes up and says, oh yeah, it's this?
You can answer the question.
I'm sorry. The answer to that question is in the generic, yes, 100%. But when you read the Powers decision from the Court of Appeals, the Court of Appeals says that even though it is a legal distinction, there may be situations where the record is not sufficiently clear to determine what happened. And if you read the last paragraph of your Kupchak decision, which was a summary judgment motion on a very, very interesting case. I'm not saying I'm entitled to summary judgment, obviously. But if you look, the court there, and I'll get it on reply, spoke about violations that were issued. So I'm not saying that I win. I'm not saying I even get there at trial.
Why would a violation take the building out of the 1906 code?
Because this was our expert said that the violations, the 5 violations that he articulated with respect to numbers were violations of the 1968 building code. Why would the Department of Buildings, why would a government agency violate a landowner for a 1968 building code provision if they didn't apply at all because the building was built in 1906. That's some evidence that the code might have applied. And what our expert said is that there was a lot of different construction, but he couldn't determine based on the insufficiency of the records
So you
before the
come down
building
to
code.
saying that a violation does mean the new code might apply.
Possible.
Just by itself.
I'm saying possibly unless there's different evidence to show that it wasn't. But again, we're dealing with a very, very old building with records that are not updated with AI and things that we have now. And if I read Powers and I read Pappalardo, the obligation is on the move-in to establish definitively that it does apply. Again, I may lose this at trial, but right now I shouldn't lose it on summary
Thank
judgment.
you.
Thanks.
Good afternoon, Your Honors. My name is Jennifer Adler. I'm appearing on behalf of the respondent. So I'll go backwards and start with the building code since we've just touched on it. So the building code issue is sort of their burden because they moved to amend, right? So their original bill of particulars does not rely.
Yeah, but on the motion for summary judgment, isn't that your burden?
Well,
to
our
say-
burden as it stands is to demonstrate that the building codes that alleged in their original bill of particulars don't apply, right? But then they cross-moved to amend, right? And in seeking their cross motion to amend was separate from our summary judgment motion. Our summary judgment motion is to determine under the facts that we have, not based on the earlier code, not the 1968 code, was it violated?
Now when we have your motion for summary judgment, don't we have this issue in there of the possibility of the 1968 code applying, and don't you have to refute that in order to prevail on summary judgment?
If they came forward with some evidence.
I mean, the record in front of the court, I mean, the motion for summary judgment searches the record. I mean, the record in front of the court now has this issue put into it that maybe the 68 code is what's applicable.
But it's only I apologize for that echo. There's nothing in the record to demonstrate that it is applicable. There's just these, mistaken violations of a 1968 code, but there's no evidence that the construction or any construction was done that would have taken it out of that.
What about a common law duty of care in this case?
Well, then we go back to the Kellerman case, which Mr. Isaac says is on, all squares. In Kellerman, the plaintiff knew exactly what happened. She knew that she stepped.
Why does that make a difference? Is that really a distinction between the cases which carries the day for you? I mean, what's the difference whether the plaintiff knows the reason or not? What the Court of Appeals said about the issue in terms of the common law duty would still remain.
Well, we don't know exactly what happened with this plaintiff. That's the problem. There is nothing in this record that identifies.
Excuse me, wasn't there testimony or deposition testimony by a witness there?
Well, the witness never saw him fall. See, the problem is the witness kept saying, when I turned around, he was falling. I think I saw him. I think he stepped out. I heard him step. I don't know which way he stepped. There's a lot of contradiction between, in Lewis's testimony, but in the end, he concedes that he didn't see him until he was already falling.
Isn't his thinking supported by the circumstances of where the opening was in relation to the window? That it was right as you stepped out, that's where the opening was. So that makes sense, that circumstantial evidence that supports that argument or position.
I respectfully disagree because you can't see anything, you don't know, and the plaintiff himself says, I lost my traction, I may have misstepped. We don't know exactly what caused it.
No, but the guy who went out before him did say, because I went back and read the testimony, he said, I saw him fall through. He didn't say, I saw him fall over, or I saw him fall around. He literally said, I saw him fall through, or he was falling through. I think the word through can reasonably, I'm not saying that it wins or loses the day, but at least it raises an issue of fact surrounding the fact that there's this giant hole right outside the window for a person who's never been in this apartment before, that's how he fell, right?
Understood, but I read that over and over again, and I went later into the deposition testimony as well, and it's like pages 565, 566. where it goes back further, and he says again, I believe when I turned back, I saw him go through. I saw him try to cling and go over the railing.
May I interrupt you for just 1 second and say that most people are like that? I think that lawyers are very assured of what they're saying, as you and I are assured. But I would posit that most people don't speak in such declarative sentences without any doubt whatsoever in any possibility, particularly in a situation of a deposition. So I don't think saying the word think, I mean, I'm constantly yelling at my kids for saying the word like in every sentence, right? So the fact that the person says, I think this happened, doesn't, to me, mean that he's not telling the
And I
story.
understand, and I appreciate
At
And
the
we're
end of
gonna
the
look
day-
at it. Oh,
At the
I'm
end
sorry,
of
you
the
have a
day, your only
question?
way out of Kelman is to say that the plaintiff there knew exactly how the injury occurred. That's your,
that is my distinction.
Thank you.
All right, thank you, Your Honor. I'll be back in a minute.
Your Honors, I'll be brief. Judge Scarpullo, with respect to the testimony, I'm not going to read it, I promise you. 517, starting on line 20 to 518, line 18. Not only do I believe that he said he saw them fall through, he said he came out, stepped to the right, and fell. Judge Friedman, with regard to the burden of proof, I'm reading directly from Powers. In this case, it was defendant's burden to prove at the outset that the absence of the railing did not violate the building regulations. I think that's binding. And Judge Scarpullo, I could put my
Well,
finger-
wait, what do you say about counsel's argument? Like, when we made our motion, you hadn't pled those sections of the building code.
She's 100% right, but
So then how are they supposed to move on a ground that you haven't even alleged?
they did move. Their expert specifically said that none of the building code provisions applied. I'm not saying that we pled it perfectly, but they said they complied with all the applicable building codes. So that's not something that you can just say outright without proving it if there are violations. I'm not saying we pled it right, we definitely have that. And I couldn't put my finger on it, but you asked me, Judge Scarpullo, the distinction. This is right out of Rivera. I'm quoting. Plaintiffs do not claim that the radiator that injured Aaron needed repair or was defective in any way. Plaintiff's claim is that an uncovered radiator in good working order, though not a hazard in a home occupied only by adults, is dangerous to children. That's not my claim. My claim is this is dangerous to everyone. Thanks for listening to me.
Thank you so much. We're going to go back on the calendar to Elfand versus Adams. So normally you have to be here to call the calendar, but I am going to hear it, but I'm going to give each side 3 minutes in this case. So you have 3 minutes to present your argument.
Do you want me to begin?
You begin.
Good morning, or good afternoon, Your Honors. This is a little bit later. And this is Jonathan Elfand, pro se appellant. To start with, I guess it's the shareholder standing doctrine that we seem to be stumbling across into this case. And the reason I say stumbling across is because I kind of stumbled when I began the initial complaint. It was written a little haphazardly because I had never argued to the courts about anything with a civil standing issues or anything. So when I presented it, it was left might be a little discombobulated in the beginning.
Did you amend it, though? Did you ever amend it? You didn't amend the complaint?
Well, I read into
That's
the
what,
case-
that's what we're struggling with now,
Oh, yes,
because,
I understand, Your Honor.
because you were given the opportunity to amend the complaint, and you did not take that opportunity.
Well, I actually read the case law, and it said that, and I presented some case law to you, to all of you, that as long as you make an affidavit affirming to the issues that have happened, that is taken by our court system as just as an amendment to the.
No, that's to amplify things that are already there, but they have to be there in the first instance, which is why I think the court was encouraging you to amend the pleadings.
Right, and I felt that once I had elaborated, like once the complaint was placed and they made the argument of the standing, I sent in an affidavit explaining how the illicit unconstitutional aspects of these statutes caused harm to myself also. So basically, I was just explaining how these unconstitutional statutes also affected me and the other staff that was.
Right, but never in a complaint.
Right, I didn't, from what I read from the case law, it wasn't necessary, but that's for your honors to decide. I believe that I've put enough into the affidavit, and it seems that Judge Kingo, the judge from the Supreme Court, expressly spoke of my argument that I had injury to myself, but he took it as an indirect injury to the company. So even if it wasn't in the complaint, the judge clearly understood it because he addressed it in his denial of my
They
complaint.
addressed your argument. That's different from an allegation in the complaint.
Right. Well, and as I expressed, Your Honor, I believe that my affidavit expressed why my arguments to the facial unconstitutionality also attributed to my injuries. So I thought that basically the argument that the statutes are facially void, all I had to do was establish that the facial voidness of the statutes also caused me harm along with anyone else inside that business when it was illegally searched. So I believe I placed it correctly. I believe the judge understood it when he answered it. And I believe that at the end of the day, the shareholder standing doctrine shouldn't even apply in the first place because the arguments to the facial constitutionality of the statutes have to do with any persons affected by it, which the void statute exception that's written into our system is clearly put in place to make it understood that when a statute is facially void, it affects anyone, anywhere, at any time when it's being used.
Thank you. We understand that argument. Thank you.
I believe that.
Your time's up, so
Okay.
you could wrap it up with one more sentence, but yeah, your time is up.
Okay, thank you.
That's what the red light means.
Oh, okay, I didn't know that. Now I know.
May it please the court, Anaga Sundarajan for the state respondents. This court should affirm Supreme Court's decision dismissing the complaint for lack of standing because the plaintiff here fails to allege a cognizable injury in fact, and in particular with respect to the state respondents. As the trial court correctly concluded, the complaint here rests exclusively on alleged injuries.
What about the amplification of the pleadings that took place to his affidavit?
Sure, Your Honor. Two responses to that. The first, as Your Honor noted, it's missing from the complaint itself, and that amplification happened at the time of the reply brief, so it's not something that the state respondents had an opportunity to respond to in writing. Even if they did, this court in Matlin-Patterson made very clear that injuries that are incidental to an injury to the corporation cannot independently be asserted by the shareholder without the corporation present as a party. And I would note, Your Honor, this is not a case where the plaintiff is without a remedy if this court affirms below. The corporation has brought an independent lawsuit in Kings County alleging the exact same facts that are present here. That's working its way through the courts and is currently before the Second Department. The plaintiff here has also brought an independent lawsuit in the Southern District of New York that was filed.
When you say independent, you mean on his own behalf?
Correct.
Okay.
Alleging again that
And in that complaint, he alleged injury to himself.
I'm sorry?
In that complaint, he alleged injury to himself?
That's correct. And the state
He did what he didn't do in this complaint.
That's correct. And
That case is proceeding.
That case is proceeding. The Southern District just set it for a hearing on November 3rd, I believe, and the state was served in that case after its briefing in this case was filed, which is why it was not in our papers. And I would just note briefly with respect to that case in the Southern District of New York, the state has conceded with respect to the specific facts that were also included in the affidavit
Sorry,
here.
the state, I'm having trouble hearing, the state conceded.
I apologize. In the Southern District of New York case, the state acknowledges that with respect to the allegations that are in the affidavit here, that he has alleged injury in fact in that complaint. So there's no reason for this court to depart.
You're really saying the distinction then between that case and this case is that in this case, he never amended his complaint to specifically allege injuries to himself where he did so in the federal case?
With respect to the specific 2023 incident, that's correct. However, there are additional defenses that the state had the opportunity to make in the Southern District of New York because those were contained in the complaint. The state did not have the opportunity to make those defenses here because, again, this affidavit was submitted on reply.
Okay, thank you.
If the court has no further questions, we ask that you affirm. Thank you.
May it please the court, Jeff Kerfman for the city respondents. We, of course, agree with the state's points that Supreme Court properly dismissed the complaint for lack of standing. The complaint contains no allegations related to searches and seizures carried out against Elfon personally. I would just emphasize one further point, Your Honor. As you pointed out, Supreme Court expressly gave Elfon an opportunity to amend his complaint, which would have allowed him to add allegations related to personal injuries. And I point the court to record 213 through 218 for that exchange. Elfon expressly waived his opportunity to amend the complaint and asked the court to resolve the case on the motions before it. So this is not a case where Elfon didn't have an opportunity to amend. It was presented to him and he turned it down. If there are no further questions, we'd ask that you affirm.
Thank you very much. 474th Avenue versus Wesco Insurance.
May it please the court, Kevin Buckley for Wesco Insurance Company. There are really no issues of fact in this case. All the facts seem to be agreed.
Counsel,
Yes.
this is a complicated record to try to move for summary judgment on, obviously. A lot of things happen. But there does seem to be some evidence in the record, especially the affidavits of some of the tenants, that the water damage that's the subject of this lawsuit did not happen until after the policy was procured. Why isn't that alone sufficient to raise an issue of fact that would defeat your summary judgment? I understand that there's a lot of evidence to support your position in this record. That's clear. But as long as there's any issue of fact, obviously we can't give summary judgment. So why wouldn't that be an issue?
Well, we're talking right now about the commencement, loss or damage commencing during the policy period. And this loss, the poor installation of the PTAC units and them dripping into the apartments, that had been something, and the floor conditions had been something that had been observed since February by CBRE.
Did the floor conditions necessarily have to be water damage?
Excuse me?
Did the floor conditions necessarily have to be water damage?
Well, the floor conditions, that is the allegation of plaintiffs. If it's anything other than water damage, it's faulty installation, and that is barred from coverage. So,
Right, but they're clearly alleging that after the policy was procured, there was new loss, new water damage that did not exist before the policy was procured, whatever the cause was. Why isn't that enough to raise an issue of fact, since we cannot on this record say as a matter of law that the water damage didn't occur before the policy was procured?
because the root cause of this, as Mr. Trevia, the plaintiff's principal, said, the damage you have been observing to the wood floor since February of 2018, it was actually the PTAC units that the root cause.
But
And
again, that goes to what my colleague said, which is that we don't know whether that damage to the floor was the same water damage that occurred after the policy was procured that the tenants said they didn't see before the policy was procured.
I think
How can we know as a matter of law that it's one and the same?
because it goes back to the word commencing. It's not whether any damage happened to occur during the policy period. If the damage commenced, this damage from the PTAC unit.
You know, I actually looked for a case that said just that, because that would have been very easy then. If there was a case that said you have to just look to the HVAC installation and that's it. But I really didn't find a case that exactly said what it is you're arguing. That was
Understood.
clear cut about that.
But there is damage that's observed, and it had commenced from the PTAC
But
units.
we don't know, the problem is, how do we know as a matter of law, and I'm repeating myself, that it was the same damage? That's the problem.
Plaintiff alleges it's from the same cause. Every time they came in and out of the apartment, they turned on the PTAC unit, turned off the PTAC unit, and it leaked. And that goes into a second defense here, which is continuous repeated leakage over a 14-day period or more. Now, this
Well,
damage...
Let me
Okay.
interrupt you again, because what I struggled with that was that we don't know if the damage or leakage was continuous, or it happened one day, it didn't happen for 5 weeks, it happened another day. We have no idea in this record whether it was continuous leakage for 14 days. How do we decide that as a matter of law?
It's not continuous, it's repeated
For 14 days?
for a period of longer than 14 days. And how do we know it's for longer than 14 days? Because the same damage they're claiming was observed in February, in March, in April. It was observed
How do we know it's the same?
No, the fungus wasn't in March and February, March and April.
This is a
There's, there are definitely other, you're talking about the floor, but there are other signs of damage that were not observed then and weren't observed until after September. And what about the ensuing loss provision?
That's on the faulty workmanship.
Right.
And
So if this is all due to faulty workmanship,
well, that goes back to what is excluded by the faulty workmanship exclusion. It says, we don't cover loss caused by or resulting from faulty workmanship. So that's the first thing that's excluded. It has to actually exclude something that's covered. When they installed the PTAC units, they didn't suffer a loss. They bought a bad product. The PTAC units then caused loss or damage to...
that's not what their experts say, though. That is not, well, let me say this. That is what your argument is, right? There haven't been any depositions of your corporate representatives, so we don't really know except for the lawyer arguments, what your corporate representatives found, right?
I believe we're all in agreement on this, that
Oh, well, we'll find out.
Why don't we hear from opposing counsel, since your time is up, and we'll find out what their position is.
May it please the court, Benjamin Shack-Sackler, Sher-Tremonti, on behalf of plaintiffs' respondents, who I'm collectively referred to as Trinity.
Let me ask you, there's a tremendous amount of evidence here that all of the damage occurred because of a faulty HVAC installation, and that there was some awareness of that, not that awareness is a relevant factor. But if all of this damage was water damage initially caused by the faulty HVAC installation, why isn't that something that occurred before the policy began, which would make it excludable from the policy?
Justice Kern, the policy covers, and I quote, loss or damage commencing during the policy period. The word commencement modifies the damage itself, not the root cause. There is zero authority.
So you're saying if something happens before the policy occurs, your client knows all about it and is completely aware of what's going on, but it keeps causing damage, and you remediate the prior damage, and then new damage occurs from the same underlying condition which existed that you knew about before the policy, that you'd still get coverage?
No, Your Honor. Actually, there's evidence in the record that shows that Trinity did not know that the faulty PTACs were an issue, but at the time...
Isn't there a lot of evidence that they
Yeah,
did know?
what evidence is there that they didn't know?
As is included in Mr. Travia's affidavit, the seller represented to Trinity at the time that the damage that was present at the property, which is different damage.
They sued the seller, so they knew that they didn't believe what the seller was telling them. They wouldn't have brought a lawsuit against the seller.
Well,
So
that
how-
happened. Excuse me. Sorry, that happened late. That happened later. And actually, the lawsuit against the seller alleges that the seller covered up the root cause of damage that occurred after the purchase within the policy period. And it's important for the fortuity doctrine because Your Honor is right. If an insured knows of an issue that's certain to occur in the future, that shouldn't be covered by insurance. But that's simply not what we have here.
You tried to schedule depositions before the summary judgment motion was filed, is that correct?
The summary judgment motion was filed before depositions were taken. That's certain. I believe that we attempted to schedule, but that was stayed, if I'm remembering correctly.
So, I mean, but what do you make of all of the February and March, the floors are buckled, everything's going wrong, it must be the HVAC?
No, actually, the CBRE firm reported that damage to Trinity when it inspected the property prior to closing and found no evidence of widespread water damage, and actually informed Trinity that there are issues that were present.
So is it your
currently.
position now that that damage, which before wasn't ascribed to a cause, to water being the cause, is in fact caused by water?
I think this record is woefully insufficient to make a determination of that as a matter of law. I think that might be a dispute.
But what do you say that the condition of the floor, which was reflected in the February 23rd, 2018 CBRE report, what do you say caused that floor condition?
Frankly, we don't know certainly what caused the floor condition, but even if it was the PTEX that caused
Well,
that
why would they be responsible for that condition since it existed before the policy came into effect?
Because that is not a condition that is part of Trinity's insurance claim. Trinity is specifically only seeking coverage for damage that occurred in August and September of 2018.
So they're not seeking coverage for the floor buckling issues?
Not issues that existed prior to the policy, no. Those issues are not part of Trinity's claim. And if I...
You're also seeking coverage for not just the floors, but for for the cabinetry, for other like utilities or drywall? Or?
That's right, Justice Chan. It's really important to note that nowhere in Wesco's brief does it point to any evidence that any of that damage was existing, even similar types of damage that are not the same damage, but none of that existed prior to the policy period. I'm happy to turn to any of the arguments on the policy exclusions if the court has any questions on those.
Well, how do you deal with the late notice argument?
Sure. So Wesco would have this court find that there's a rule that there could be no investigation of any sort of damage.
I don't think that's what, I think they're saying, here's the number of days, and it fits in the number of days that normally we would find late notice.
So the standard for prompt notice provision, and I don't think there's any dispute here, is that it's reasonable under all the facts and circumstances. Here, we have a large residential apartment building, complex issues. When Trinity first started hearing about damage in August and September, the complaints started trickling in. Once it learned that, hey, we might have an issue here, it hired an engineering firm and conducted an investigation. And 4 days after it learned of that the results of that investigation, that, hey, this is not what the seller said. This is actually a problem with the PTEX. 4 days it filed its claim. That cannot be unreasonable as a matter of law.
It may be as a matter of fact, but not as a matter of law, you're saying. Okay.
I think there might be a factual issue here, but certainly not as a matter of law. Just briefly on the latent defects exclusion.
Time's up, so,
Okay.
but we're familiar with the briefs, and we'll look at that.
Thank you, Your Honors.
Thank you so much.
Thank you. I'd like to just jump to the late notice provision. The condition in the policy for late notice says you must notify the insurance company if there is loss or damage. It doesn't say if you're going to make a claim, if you think your claim is warranted, anything. If you have loss or damage, you must notify the insurance company. Now, Mr. Trevier...
You're saying even if it wasn't covered by the policy?
If there, well...
Don't they have to decide whether they think it's covered by the policy? What if what if their loss or damage has nothing to do with your policy?
Well, if it's covering the building that the policy covers, then yes, they have to give us notice of that because that's an insurable property that we now have the right to come in and look and see, hey, what's causing this? Is this covered? While they're doing their investigation too to see is this a covered loss, we get the same opportunity. Look what happened here. While they waited from June, July, August, September, while they brought in rapid response, while they brought in Horizon to do all these investigations, The PTAC units continue to go on, they continue to leak, the damage progressed, and it's at the cost of my client. As you, Your Honor, noted, mold then formed because this wasn't addressed. Had we been giving prompt notice, it doesn't take much, call up, hey, we're noticing problems with our floor. Could you come down and look?
Well, wait a second. Don't you inspect the property before you issue insurance? See, I guess we don't know because you didn't get deposed. But I would assume that your people come in and look at the property before you issue insurance.
They did not inspect the floors of this property.
Okay. You're saying they wrote an insurance policy, this big of an insurance policy, without doing any investigation?
I'm not saying that, Your Honor. I'm saying they did not.
Is there any legal requirement for them to do an inspection before writing a policy?
There is no requirement for them to do an inspection before the policy, and in this case, when the policy went into effect, the building was 60% occupied. So as you can imagine, it's difficult to get into tenants' apartments.
No, I get it.
So, and I would just leave this with saying that, you know, this court had said in Power Authority that there are no exceptions made for losses that may ripen into a claim under the late notice provision. We're entitled to notice to come in and find out what's going on. Thank you.
Thank you. People versus Pedro Vinet.
Good afternoon, Your Honors. Elena Marks of Davis Polk and Wardwell, pro bono counsel for defendant appellant Mr. Pedro Venant. Your Honors, this case is about Mr. Venant spending 3 years in prison for having a knife clipped to his belt.
Can we talk about the real problem here, which is whether this is a proper argument to be made on this appeal? This was an appeal from a judgment of resentencing, and we have held that that's a very limited appeal that only brings up very limited issues. So the real question I think that we're grappling is why would this issue be brought up in the context of a resentencing, an appeal from a resentencing?
Yes, Your Honor. We submit that this is a very sui generis procedural posture. Neither side has identified any analogous case before this court where a change in the law rendered the underlying conduct no longer criminal at a point where the defendant did not and could not have raised the issue to this court or any other court. The situation here is fundamentally different from the situations presented by the cases cited by the people, where a change in the law was raised before another court and then was again raised before this court. In effect, the defendant was trying to get a second bite at the apple. That is not the case here.
Okay, but I guess I want you to deal with the standard, which is that with resentencing, you either have to show that the sentence was invalid as a matter of law or harsh or excessive, the sentence. But your argument doesn't really seem to be focused on what the sentence was. It's about the underlying merits of the case. So how do we even get to the issue where that's not a proper issue to be considered on a resentencing?
Well, we think that we are asking the court to consider the merits of Mr. Venant's conviction.
Right, but that, again, that seems to be beyond what you do on a resentencing, where you're just looking at the sentence itself. You're not looking at the underlying merits.
Well, respectfully, CPL 47015 grants this court broad interest of justice powers. That statute was constitutionally inscribed and could not have been.
Can I ask you, I heard you say something about 3 years. Wasn't he sentenced to 364 days?
He was resentenced to 364
Right, so he didn't serve 3 years for this crime, right?
He did. He served 3 years and was later
He's in on
resentenced
another
to
case.
Oh, right.
He is currently incarcerated on another case. However,
Right.
he served nearly 3 years for possession of a gravity knife and was later resentenced to 364 days.
Right,
after
so
his
so he's already served that sentence, so there's nothing we can do to fix the fact that he got sentenced in 2016, correct?
Yes, correct.
So the fact that he served that time, there's nothing we can do about that now because he served that time.
Yes, we are asking the court to reach the merits of his conviction. And the reason.
In a collateral proceeding on for resentencing. You're asking us that, why? Because we can't fix his sentence, so we couldn't reduce his sentence because he's already served it. So how could we reach the merits?
We think that this is not a collateral attack. This is not a separate proceeding. We are still here on the gravity knife conviction on a
You're here on the appeal of a resentencing. You're not here on the underlying conviction. That's not what's before us. It's a very, very narrow type of appeal. This isn't the initial appeal from the case. This argument would make complete sense.
Yes, but
The underlying conviction has been upheld.
yes, but where justice so requires, this court has exercised jurisdiction over the merits of a conviction on an
Yeah,
appeal
but
from a
that's usually the interest
resentencing.
of justice because an issue hasn't been preserved. It doesn't go normally to the scope of review that we talk about interest of justice. So.
That is often the case. However, we identified several cases on page 3 of our reply brief in which this court, in particular in Ramos, reached the merits of an appeal on an appeal from a resentencing.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Hunter Barron for the people.
Counsel, do you want to address the case that she's referring to where this court did allow reviewing the merits in a resentencing?
Yes, Your Honor. Ramos, I believe, was an appeal from it was an appeal from the resentencing, but I believe the judgment of conviction as well was wrapped in that appeal. However, even putting that aside, Ramos predates the CPL and in this court's decision in Golb are
CPL 450?
CPL for the entire CPL, I believe, that Ramos predates.
I mean, if we hear this appeal, wouldn't we essentially have to hear every appeal, every person in the interest of justice who is ever convicted of possessing a gravity knife?
Yes, Your Honor.
Yeah, that would be a tough thing to do, right? Because
Sure.
everyone would want that conviction expunged or overturned because it is now no longer illegal.
Yeah, Your Honor. I mean, the law values finality, and there's a reason that there's a presumption that
Have
statutes
appellate
don't.
courts addressed this with regard to the change in the law of gravity knives?
Not that I'm aware that they have addressed this particular issue with resentencing, but I think the statute is pretty clear, as Justice Curran noted, that really the only grounds one can raise on a resentencing appeal have to do with the harshness or the legality of the sentence. I do want to address the constitutional challenge my adversary raises in the reply brief in point 1, provided Your Honors with additional cases today addressing that challenge. The first 2 cases, Taurus and Mellon, recognize that this rule predates the CPL, which would suggest that it does not violate the Article 6, 4K of the New York Constitution. The second is I would note that, to our knowledge, my adversary has not provided the AG notice of this particular constitutional challenge, only the vagueness challenge, and I believe that would be required for challenging the constitutionality of the CPL provision here. And lastly, I would add that the defendant here did have the opportunity to challenge the vagueness of this law and raise an interest of justice claim in his original direct appeal. So unless Your Honors have any other questions.
Thank you.
Thank you.
Your Honors, we provided 3 bases under which this court may reach the correct result here, but I would like to briefly discuss the third, which is the exercise of the court's interest of justice powers. The court's historic and constitutionally inscribed power to vacate a conviction dates back over 100 years. It's predicated on the idea that, as the Miles Court put it, the law is found in justice, and when the application of the law does not yield a just result, the court's interest of justice powers can bridge that gap between the technical confines.
Disregard the language of the statute, which sets out the parameters of what questions to consider in a resentencing?
Well, as the court in Ramos specifically noted, the legislature cannot limit the court's jurisdiction because it was constitutionally inscribed.
So you're saying we have unlimited ability to, if we think that something should be fixed, regardless of the CPL, regardless of anything else, we can just fix it?
Certainly not unlimited, Your Honor.
Wow, that sounds like what you're saying.
Certainly not. Under the circumstances of this case, where Mr. Venant served 3 years on a sentence that was later reduced to 364 days for conduct that is no longer considered criminal. Thank you.
Thank you so much. Healy versus, oh, and thank you very much for your service in this matter. We appreciate it. Healy versus Trinity Hudson.
My name's Kevin Brennan. I represent the defendants, appellants. And I understand the issue on this appeal to be whether the ladder, the safety device under Section 240 Subdivision 1 was properly placed, that the court below found that there was a question of fact because of its placement so close to the two-step staircase, and I understand that's what the opposition to this appeal is. And the essence of the appeal is that the risk for which the ladder was needed, it was an A-frame ladder, is wholly unrelated to the way Mr. Healy was injured. And
He came down from the ladder. The ladder was perfectly fine. There was nothing going on. He came down from the ladder, and this is different from all the other I fell off the ladder cases because
and I stepped down off into a hole or something that was below the ladder.
As he testified, I read his testimony. Both his feet were on the floor, and he just misstepped on the steps going down.
Yeah, that's what he.
So this is not a shaky ladder case.
Right. No, he said there's nothing wrong with the ladder. He got down, like you said, he got both feet on the floor. He testified that he turned to go down the stairs. And there's.
He said, I think there were 2 feet between when I turned and where the stairs were.
The photo that showed the ladder, that's part.
That was not that time, right? I understand.
And he said, no. He described the ladder as being perpendicular to the stairs and at least 2 feet away from the stairs.
Right. So the photo doesn't reflect what happened at the time, right?
Yes.
Comes down from the ladder, turns around, and there's 2 steps down. He missteps on one of the steps.
Right, yes.
Okay. Yeah.
Yes.
At that point, when he stepped off the ladder, his duty, what he was working on, which was removing something from the pipes, that was the height-related job, and that was finished, correct?
That's my understanding from the case. I think it was, I'm not good at this construction stuff, but I think he said he was doing something with a conduit in the overhead ceiling, and you can see there's 4 pictures that the opening is there. So he said he went to go down the stairs. I can't remember if he said why he was going down the stairs, but he had finished his work and come down the ladder. That's my understanding. Okay, thank you.
Thank you and good afternoon, Your Honor. Michael Beniak was for the respondent plaintiff. Your Honor, it's quite simple.
Was there a safety device that should have been used here that wasn't?
No, this is not an issue of whether the ladder was appropriate or inappropriate, safe, unsafe. It's a placement issue. As this court has routinely held, as the statute itself makes crystal clear, not only does a defendant, in this instance here, the owner of the property, have an obligation to provide safe equipment, assuming for a moment.
But there's no dispute in this case that he did not fall from the ladder, and that when he fell, he was no longer on the ladder. So how do we get into the parameter of 240?
It's where they place the ladder.
But what did that have to do with this accident?
The placement of the ladder is essentially put in an area for him to do the breakers overhead. So there's no question.
Right, but there's no question that at the time this accident occurred, he had stepped off the ladder, his 2 feet were on the ground, he was no longer on the ladder. So how does his falling down the steps have anything to do, you're saying because he was too close to the steps?
Yes, The ladder that was placed here,
But the obligation is to provide a safety device that's safe. What was unsafe about this ladder?
the defendants must provide a safe device here, whether a ladder or not, and it has to be placed in a safe
It was
manner.
more than 2 feet away, wasn't it?
No, see, there's another point where the defense in their moving papers, especially in their reply, focus on 2 feet, at least 2 feet. We're talking about for the want of 24 inches, where if defense were to have it their
Do
way,
you have any case where we've said that a ladder, that someone didn't fall off the ladder, the person was 2 feet away from the stairs, that was a 240 case? I didn't find one, maybe you did.
well, I'll start with respect to, with what the lower court here said. First,
No, I'm not, obviously, there's an appeal from what the lower court. I want to ask you whether you found a case that found 240 liability, where the ladder worked perfectly well, there was a 2 feet distance from where the person got off the ladder and went down the stairs. Anything like that?
if the court were to look at Cohen versus Memorial Sloan Kettering, decided by this court in 2008, I'll just read a passage from there. To conclude, I should start with the preamble of it. As the defendants there would suggest, the sole cause of the accident was the plaintiff's own negligence, which is here they're going to say.
We're not arguing that, I'm just trying to figure out if you think that there are cases out there that say that you can go down a perfectly fine ladder, take a step around, and then miss a step on a stairway, and that's a 240 violation.
Well, again, quoting from Cohen versus Memorial Sloan Kettering, to use the ladder, choosing to place it as he did, or choosing it to use in a manner as he did, to conclude it's not a 240 violation would turn it on its heads for the purposes of Section 241, which is to protect workers by placing ultimate responsibility for safety practices at construction sites.
Can you tell us what the specific facts were in Cohen versus Memorial Sloan Kettering? Where was that ladder in relation to the fall, or how was it placed that it constituted a 241 violation?
With respect to where it was pointed, it was essentially it was placed, and there was obstructions around the ladder. So it's
Okay, we don't have any obstructions. He got off the ladder, he stepped, there's 2 feet. That's a completely different situation than I slipped as I was getting off the ladder because there was garbage on the floor.
well, no. See, the slipping while there's garbage on the floor or there's something under my feet as I come down would be tantamount to the Nieves case, which the appellants cite to, which is wholly in opposite here. This is a case, there's construction going on outside this very courthouse right there on Madison Avenue. The street is opened, there's traffic going by. If we are to have a precedent where if we give a worker a quote-unquote perfect ladder, it's the best ladder that could ever be used, but if the defendants can escape responsibility if the ladder is not placed in a situation that assures the safety of the person using
Well,
it.
if it was placed in a bad situation, you fell off it, that would be a perfect 240 case. Totally.
Well, there is,
Placement can be good. But thank you. Thank you.
thank you.
Unless you have a question for me, I don't need my reply time.
No. The next case is Inc. Mango versus Warren, and I am recused on this matter.
Good afternoon. May it please the court, Richard Altman for the appellant, Inc. Mango. I have 4 points to make, and I'll try to cover them briefly. First of all, the respondent makes much over the fact that a lot of the issues that were raised in this appeal were not raised below. Well, on a 3211A7 motion, which is brought here, or even in the court below, the court's obligation is to review the entire complaint and determine whether it states a cause of action in any way, shape, or form. In addition, when documents are submitted, as they were here, the question then becomes whether the plaintiff has a cause of action, not whether one is stated.
This isn't a regular case. This is a defamation case. There's a heightened pleading burden, right?
Yes, there is.
So let's deal with that.
Well,
Let me ask you, let me start.
surely.
Why is this not a slap?
Why is it not a slap case? Because there's sufficient evidence of malice to have met the high pleading standard. That's the short answer. The changes that were made with notice, the changes that were made without notice, the failures to interview people who had something
interview 30
positive to
people?
say. Your Honor, will you?
Didn't they interview 30 people?
I'm sorry, I didn't hear you, sir.
Didn't they interview 30 people?
The number, that's not the number, that's not the question. The number of people is not the relevance. The question, the issue becomes,
Did the author send questions to your client?
yes, there was a request
So there were,
for comments.
so there
as-
was investigation. We all agree there was investigation and fact-checking going on, correct?
Yes, there was. Yes, there was.
So
But
then where do you raise an issue of actual, not spider ill will, but actual malice?
there is sufficient evidence.
Which is
it.
what?
The evidence, just a moment, please. The omission of, for example, the fact that the ARR was always included is a devastating omission because it says that the plaintiff, the appellant, is in fact committing securities fraud. And the mere omission of that is a factual statement. And that is sufficient in itself to be sufficient under the anti-SLAPP law. The anti-SLAPP law has been far too broadly interpreted here. There's no question about this. And in fact, I have made arguments that it's basically unconstitutional because of the fact of the way that it takes judgment as to facts away from a jury and gives them to the judge without any opportunity to respond. So, the fact is here that we
So
have
let me
statements
just-
which are,
May I interrupt you for one second?
course.
So you're saying because not all facts that your client wanted to be included in the article were included raises an issue of actual malice?
no, that's not what I'm saying at all.
Okay, well then
I'm
what
saying,
I thought that's what you just said, because
I'm
there
saying
was
that
no, counsel, I want to hear what you have to say, you just have to wait for me to finish my question.
indeed.
okay? I thought you just said that because there was no discussion of the ARR, that shows actual malice.
It was omitted.
Right.
It was omitted when it was an essential part of the allegation as to whether there was securities fraud. The fact that the source of this article was a disgruntled employee who had something to say in
Wasn't that disclosed, that friendship disclosed in the article?
It was disclosed. Yes, it was disclosed. But the fact is that it was not, it was taken for granted that what she had to say was true. The point I'm trying to say is that there's too much here which is circumstantial and may indeed be evidence of malice. And I think that the lower court should have allowed discovery to commence, notwithstanding that it's a 3211 motion. The court has the power to allow it, not whether it's asked for or not, because of the implications here under the anti-SLAPP law of enormous liability for attorneys' fees, of people with legitimate claims to be facing to be facing media giants and who can say whatever they want and say, First Amendment, I can say whatever I please, and if you sue me for that, I'm going to go after you for attorney's fees. I mean, the whole anti-SLAPP framework.
Well, or
has been-
maybe the response to that is more speech, right? Isn't that what we say? If you don't like the speech, my speech, the response is more speech, not punishing speech.
Well, I've been doing a lot of reading onto the history of the First Amendment, for example. And the First Amendment, at the time of the First Amendment, there was no question that defamation law was not included under the First Amendment. And so it's been chipped away for centuries. And you have here...
Can you just wrap up? Your time is up.
I will. The original intention of the anti-SLAPP laws was to protect small people who are threatened with liability by large corporations, and it's turned into its opposite.
But what you say may be true, but that's the legislation that was passed.
I understand that that's legislation. I'm challenging its unduly broad application to situations like this, where there are some serious questions as to what they knew and when they knew it, and this calls for discovery of the early drafts of the article, of the responses. The facts are very complicated here. You cannot just simply say they didn't prove malice and the case is over.
Okay,
So,
thank you.
May it please the court, Your Honors. Elizabeth McNamara on behalf of Business Insider and Katie Warren. What you didn't hear from appellant is that this complaint clearly identified only 2 sentences that it was challenging. And it defined those 2 sentences as the defamatory statements. On appeal, they've tried to expand this, as you've heard, and I think as you've appropriately noted, this is a defamation case. And under the CPLR, under 3016A, you have to precisely identify the challenge statements.
Well, why don't you start with counsel's argument that this is not a SLAPP case?
Well, Your Honor, he hasn't. It is a SLAPP case for the reasons found by the court below, and I think is self-evidence. It's a public forum. It's an article that was written in a leading publication, Business Insider, and it clearly concerned a matter of public interest.
And didn't your client earlier say they were the startup to watch?
Exactly. That was going to be the next thing out of my mouth. They had previously reported that this is the next startup to watch. This was a follow-up. It clearly was newsworthy.
So how do you deal with counsel's argument that there were material facts that were not presented in the article that would raise an inference of actual malice?
Your Honor, what we heard today and what we've seen in the paper, the only thing they identify is that the ARR reference was not included. What was included, consistent with the response from Ms. Sir to the factual query, is that they reported that she contended that financial and projections were provided. ARR...
That was in the article, but not specifically the ARR.
Yes, but ARR is nothing other than financials. So it was, in fact, in the article. In effect, what they're arguing with regard to actual malice, it has more, they're asking this court to function as an editor, to opine as to what should be included, what shouldn't be included in an article.
And what do you say to counsel's argument that because the person who was the main source for the article was a disgruntled employee, that raises an issue of actual malice?
Well, 2 things, Your Honor. First of all, as you've noted, there were over 30 sources. This was one source amongst 30. And the affirmation from Ms.
And I assume that most negative articles wind up coming, at least initially, from someone who's not happy with the subject of the article. So
that may well be the case. And as this court found in Griffith versus Daily Beast, that it was not even grossly irresponsible to rely on a friend as a source. So most certainly it isn't sufficient to establish actual malice when there isn't a shred of evidence in this case that there was any concern from either Business
Was there any
Insider or
disclosure, was there any disclosure that the source may have been someone who was friends with the author of the article?
Yes, it was reported in the article, Your Honor. There was an express notice to readers that one source that the writer was friendly with one source and was a former employee. That was included in the article, which is all that needs to be done here, particularly when this is one of many. I mean, at the end of the day, what their complaint from an actual malice perspective is that this is really, it should have been reported differently rather.
That's the ARR, and that mention of ARR is claimed that should have been with the line that has the deck that was presented to investors.
Correct, Your Honor.
Is that the only thing that needed to be presented to the investors?
No, Your Honor, there's a wide array of financial data. What is critical information to one investor may be very different as to another investor. There's ARR is but one form of financial data that is relevant to investors. And the article did expressly provide that financial projections and finances and projections were provided to investors. Notably, the appellant here did not deny this statement when presented to her in the fact-checking process, just like she did not deny that she had falsely told people that Oprah was an investor in the juggernaut. She did not deny this. Now, they stayed on appeal. They say, this is a question of fact, and she was denied. But I ask Your Honors to scour the fact-check process, particularly page 81, and the response from Ms. Sir to that query about Oprah Winfrey. She does not deny it. And when you're on page 81, you can look at the next question, and she's asked something different, and her response to that question is, this is inaccurate. Clearly, she knows how to say something is inaccurate, and she chose not to do so with regard to the Oprah Winfrey. The same is with regard to whether she told some investors one story and other investors another story. In that circumstance, the response was simply, well, sometimes things can be different on different days. She didn't deny it again. The opinions were fully substantiated, Your Honors.
Thank you.
Thank you.
Counsel, you have a minute?
Couple of points. First of all,
Let me ask you, I just want to make sure, in your complaint, you pled defamation and defamation per se, correct? Based on certain words, not that the tone of the article was defamation by implication, and you didn't say anything in the complaint about the headline, correct? I just want to make sure that
I'm
we're
a
all.
little edgy about saying this, but it was not my complaint.
Yes, so you're correct, and I don't ascribe it to you. But the complaint that we are looking at didn't have a cause of action for defamation by implication. It also didn't have a cause of action with respect to any of the statement or the statement that was the headline of the article, right?
And my argument is that it does not have
I agree,
to.
but I mean, so we have the CPLR 36.
You have a defamation by implication argument, you have a defamation from the headline, and you have the articles which were in the reply brief about the importance to investors of numbers showing what are your projected gains, profits, losses. Obviously, if you're coming to me and asking me to invest, that's what I'm going to want to see.
Okay.
And in fact, because of this,
Can you wrap it up? Your time.
I shall. And because of this article, directly because of this article, my client lost a $5 million investor and has in fact been socially ostracized.
Okay.
So the damages are real here.
Okay.
Damages are real. And
Thank you.
I just urge the court to take a closer look at the iffiness of a lot of the facts here, and we should allow it to go forward. That's
Thank
my
you.
argument. Thank you very much.
Our next case is Quach versus C&A Jerome Realty.
Good afternoon, Your Honors. May it please the court. Michael Lazamis for the appellates. Plaintiff filed the action that we're here for today, claiming that the defendants, my client, the appellates, were negligent in their management control, occupation of a premises located, or a sidewalk located adjacent to the premises and in front of the premises of 3400 Jerome Realty, the location of a beauty store. After the action was filed, and after plaintiff testified, plaintiff files a separate action against an entity called Wak Wak Corp. Wak Wak does not appear in the action, and plaintiff files a motion for default against it. In connection with the motion for default, plaintiff testifies in an affidavit. And by the way, this is for the same date of accident, January
We're
8th.
familiar with the case, but why isn't the later case, why isn't that an inconsistent statement about where the accident occurred that should be rejected?
It is an inconsistent statement, but it is also a judicial admission to which the lower court relied in issuing a default judgment order. Plaintiff is now bound by that. Plaintiff cannot change the site of the accident. He says clearly, I was
Is that your
caught,
sole argument, that it's a judicial admission? Do you have another argument?
and it's a estoppel. He's stopped from claiming.
Because you can't say something that, you can't take two inconsistent positions, right?
Correct, and
Either he
this is-
fell in front of Wak Wak or he fell in front of Beauty Cutie.
Exactly.
And there's a store in between the two of them, so he couldn't have fallen on the crack of the line in between them, right?
It is not that
Yes,
kind of case.
got it.
That's, unless the panel has any questions, that's basically it. The location of the accident is a critical element of the case in which I'm defending, and he has put himself elsewhere. Thank you.
Good afternoon, Your Honors. May it please the court. Jason Steinberg, I represent the respondent. The Court of Appeals held in Kaufman versus Lilly, and this court held in Rojas versus Romanoff. Collateral estoppel effect will only be given to matters actually litigated and
Even
determined.
if we put aside the issue of collateral estoppel, there's also another principle that you can't make inconsistent statements. You can't tailor the testimony to counter what you've said in a previous statement. So this is a clear statement by the plaintiff in the first case as to where the accident occurred. And then in the second action, it's a completely inconsistent statement. So putting aside estoppel and the technical requirements for estoppel, why isn't this case knocked out just by inconsistent statement?
The statement in the second action, first of all, is not an admission because it's not clear and
Your
unequivocal.
client swore in an affidavit. That could not be more of an admission than if he stood up and said this. He said, I fell in front of Wak Wak. That's how you got your judgment. You would not have gotten a judgment in that case unless he put in an affidavit. And did you put in was it you who also put in the affidavit?
No.
Oh, good.
But
But somebody else, some lawyer, put in an affidavit that said he fell in front of Wak Wak.
If I may, I think it's also important to understand why the second action was commenced.
No, it doesn't matter why it was commenced. He swore under oath that he fell in front of Wak Wak. Now he can't in this action say, no, I didn't mean that.
That's not what happened, though.
My sworn statement is not true.
I think we're getting the timeline messed up because my client testified his deposition in the first action before that affidavit was signed.
No, but we're talking about, it doesn't matter when he said it, it matters when it's being used. Now it's being used after you got the judgment to say, no, I fell somewhere else.
When you move for a default judgment, all right, you really only have to show that your action has potential merit, okay? So when you sign these bare bones affirmations, okay, the clients sign them at the direction of the attorney, the state, this happened adjacent to the property.
But doesn't the court rely, the court relied on that affidavit in issuing the default judgment?
Yes, because based upon that, the court can find that there's potential. Remember, it's not a definitive determination that there's negligence.
It absolutely, have you, 3215 says that you have to put in order to get a default judgment, you must put in facts constituting the claim. That means you have to say, I fell in front of Wak Wak to get a judgment against Wak Wak. You could not have gotten a judgment against Wak Wak without that, correct?
That's correct.
Okay.
Now, at the same time, I think it's important to note, because this is in the papers and it's not disputed by the defense attorney. It's not disputed that the section action was commenced because questions were asked at the deposition. Why was the water, did you ever see water coming from the Chinese restaurant? Did you ever see plumbers there? The suggestion or implication being that they caused and contributed to the area, and I say adjacent loosely because adjacent really can mean a lot of things. You know, so when if you're asserting in a complaint a fall adjacent to a property, the bill of particulars is thereafter going to specify and amplify those pleadings. So I think it's unfair to hold my client to this qualified as a
one second. You think it's unfair that your client swore in a statement that he fell in front of Wak Wak, and then he's trying to submit testimony that he fell in front of Beauty Cutie? You think that that's unfair to the defendant, to your client?
I think that's an issue of fact.
Is it fair to the court to ask the court
Right.
to accept you're saying you fell in front of Wak Wak, and then the court should accept that you fell in front of Cutie Beauty?
I'm trying to say that I don't think I think that is a issue of fact for a jury to decide, and it's evidence that goes to the weight of my client's testimony as to what adjacent necessarily means. He's never asked that question.
Thank you.
Just briefly, unless the panel has any questions, the reason in which the second action commenced was completely irrelevant. It was commenced, plaintiff swore to facts underlying it, and it resulted in a judgment based on his averments.
Actually, how did that commence? Is it because when you were asked to produce leases to your property, you produced the lease to Wak Wak?
I don't know why they commenced the other action. I can't put myself in their head. I do know that the timeline is that in discovery in my action, the action we're here for right now, a lease was exchanged pertaining to Wak Wak.
Thank you.
Thank you.
Molina versus Chatham Towers.
Good afternoon, Your Honors. Anthony DiStefano on behalf of Plaintiff Appellant. There were no material inconsistencies between what my client told his boss immediately after the accident as to how this accident happened and his deposition testimony years later. Nor were there any material inconsistencies between what my client testified to at his deposition and what the boss testified to at his deposition.
He said no one held the ladder and he fell off.
Correct. And with respect to the ladder, this is a shaky ladder case, and that's what my client said to his boss immediately after the accident. The ladder was shaky, and I fell off the ladder.
And his
And I
boss
hurt-
wasn't there with him.
And the boss was not with
No
him.
one was there with him.
Correct, Your Honor. And under this court's decision in White, I believe that if there was any inconsistency between the testimony of the boss with regard to the positioning of the ladder and that the boss said, I put the ladder there and I believe it was in the same spot as it was when I left it, that under White, that is not a material inconsistency because that is exactly the facts of White. And for that reason, we ask that the court reverse and grant my client summary judgment. There really are no questions.
This was a case where you actually did fall from the ladder, right?
Yes.
Right.
Unlike an earlier case we had,
Right.
where he didn't fall.
He didn't
from the
fall
ladder.
from the
Which is
ladder.
why I used the euphemism shaky ladder case, Your Honor, in deference to you. Thank you.
Thank you.
Good afternoon again. Jennifer Adler on behalf of defendant Chatham Towers. So
Let me just start by saying, you know that the First Department has said that the fact that the accident isn't witnessed doesn't prevent summary judgment, right? So what have you got that would raise an issue of fact as to how the accident occurred?
it's not about how the accident occurred. It's about, did the accident actually happen? So
What evidence is there to contradict that the accident happened?
what happened is, we have Melina's, we have Jesus Montel's testimony, and he says the ladder was steady, the ladder didn't shake. I left the room for 5 minutes. All 4 feet were touching the ground. The ground was free of debris, the ground was free of garbage, and when he returned, about 5 minutes later, the ladder was in precisely the same.
How does that contradict the plaintiff's testimony about how the accident happened?
Because we don't know what actually happened.
Well, we do know what happened. The plaintiff testified with uncontradicted, this is how the accident happened. So that's why I again say to you, how do you distinguish our cases that say that simply because an accident is unwitnessed, that doesn't call the credibility of the plaintiff into account?
Sure. So in the cases cited by plaintiff in his brief, in those cases, there was no dispute. In every single one of those cases, there's no dispute that the accident happened. There is no one saying, there's not a defendant that says, well,
Right, but he
I
didn't say
don't
the accident, the supervisor didn't say the accident didn't happen, nor could he say the accident didn't happen because he was not in the room when it happened. So there's no evidence in the record that supports that the accident didn't happen, or is there? What's the evidence is there?
I'll submit that it is our argument that his testimony that the ladder was in precisely the same place, that plaintiff went up and back to work.
Right, but he said when he got up on the ladder, the plaintiff was holding the ladder, and when plaintiff went up on the ladder, no one was holding the ladder. So even if it was in the same place, it's a very credible argument that they were in different situations, and just because it didn't fall when plaintiff was holding it for supervisor, why should we disbelieve that it did fall when no one was holding it for plaintiff?
But why should we not believe his supervisor who
The
said...
supervisor didn't say the accident didn't happen. That's what I'm struggling with.
Yeah, is there any contradictory testimony? You keep saying that there is an issue. Tell us, what is that issue?
Well, it's to us, it is our position that this accident didn't happen at all.
But it's just you saying it as an attorney. What is the evidence in the record to support that this accident didn't happen?
We believe what supports it is that there's no that Montel testified there's no evidence that he fell. The ladder was steady. The ladder didn't shake. Everything was touching the ground, and that when he came back, the ladder was in less than 5 minutes later, precisely the same spot.
So you're saying we should find the plaintiff's testimony inherently incredible based on that? That's your argument?
Well, at least let a jury determine credibility.
Okay.
Thank you.
Thank you.
Yeah, I mean, that's why I began my argument with there's no material inconsistencies in my client's own testimony between what he said immediately after the accident happened. As soon as the boss came back into the room, that's exactly what he told the boss. The ladder was shaky and I fell. And that's the same testimony that he gave years later. And the testimony between the two is identical in almost every respect. And for that reason, there is no question as to my client's credibility, which would otherwise defeat.
Let me just ask you, the supervisor said that's what he said to me when he came back, right?
Yes, Your Honor.
And he didn't say, and I didn't believe him, did he?
No, Your Honor.
There's nothing in the supervisor's testimony that says, I didn't believe that that's what happened.
No, Your Honor.
It's just by implication, attorney implication, right?
Correct, Your Honor.
Okay.
Thank you, Your Honors.
Thank you. And the last case today is Lash versus Modular Holdings.
Good afternoon. May it please the court. Jordan Peterson on behalf of the TDR defendant appellants. This case does not belong in New York. The case is about the management of a Luxembourg company and the decisions that the board of that company made.
Below, explain why it changed its position, why it initially held that the case should be dismissed on the ground of form nonconvenience, and then in a later decision went the opposite way. Did it explain why it was going the opposite way on that issue?
Not directly, Your Honor, respectfully to the court below. The best that it did is it laid out the contentions the plaintiff made in the motion for leave to amend and said it was granting free leave to amend. Then it got to the second motion to dismiss and said that there are new allegations in the complaint that bear upon the analysis, and therefore it is no longer dismissing.
Let me ask you, we have given a lot of credence in some of our decisions to plaintiff's residency and held that that's an extremely, extremely important factor in the analysis. How do you counter that, since it's undisputed that 4 of the plaintiffs are New York residents? What are the factors that overwhelm that and argue for it being dismissed?
That's right. This court has looked at the residency of plaintiffs, but that's not dispositive, particularly here when 2/3 of the plaintiffs are not New York residents. The other factors of the 5 under the Court of Appeals case law relate to the availability of the foreign forum. Here, there's no real dispute that Luxembourg is an available forum that has process, that has appeals, that has sophisticated judges to handle these claims. Luxembourg also has an interest in this that's greater than New York.
So there are a lot of different agreements here and a lot of different transactions. I mean, the idea of coming into New York was not completely alien to the parties' transactions. I mean, why? I know it's your position that the equity purchase agreement, which calls for a New York forum, does not govern this situation. Why is that?
What plaintiffs attempt to do is basically take a sale of a business contract with an entity called William Scotsman, and then turn that into a shareholders' rights agreement that governs all the conduct going forward when they held equity in the parent company, Algeco Scotsman. So that's the reason the 2013 contract isn't relevant sort of as just a principle of absurdity. But more importantly, the harm that they allege doesn't come from the 2013 agreement. They don't allege, for example, that the sale didn't happen or that that contract was fraud.
Let's focus on the 2017 transactions, because that is where they allege that the harm. Why does looking at those transactions, why does that argue against keeping the case here?
And for those actions, they all occurred under the direction of a board that was making decisions in Luxembourg. That's clear from the minutes. The plaintiffs don't challenge that that's where the decisions were being made. At best, they argue that TDR was making decisions in London as well as in Luxembourg. The claims relate to the internal management of that company. In addition, 2 of the 3 restructurings were sanctioned by a UK bankruptcy court. So again, it doesn't point to New York, it points to dealing with that in London or Luxembourg. What's important here as well is plaintiffs aren't surprised that they ended up in Luxembourg, right? And the trial court below found that the first time around, right? They knew that they were getting equity in a Luxembourg company. And they knew, by the way, that they got that equity pursuant to a subscription agreement that called for a Luxembourg exclusive forum. So if 2013 and those agreements are relevant, the agreement that's relevant on that issue is the one that gave them the equity they now claim was devalued, and that agreement had an exclusive Luxembourg forum.
You want to address the jurisdictional question at all, whether or not there's in personam jurisdiction over the defendant?
That's right. The jurisdictional arguments are, in some sense, parallel the forum nonconvenience arguments. Their primary hooks are allegations about things that happened in 2013, not about the harm that happened in 2017, which relates to decisions made in Luxembourg, not here. The best argument they have is that they felt the harm here, but that doesn't provide enough of a hook for the court to bring them into New York when the action was happening.
You're saying when we look at the issue of personal jurisdiction and specific jurisdiction under CPLR 302, we should be looking at the 2017 transaction and whether in that transaction they availed themselves of the benefits of doing business.
That's right, Your Honor.
And that your argument is obviously they didn't.
Yes, and they didn't. Those actions were happening abroad in Luxembourg.
And there is some indicia here of business in New York, bank accounts, lawyers, et cetera. Why isn't that enough?
This court and the Court of Appeals have held that simply using New York lawyers or a New York financial institution as a clearinghouse doesn't automatically bring every case into New York. That's particularly true here, where their other hook related to the William Scotsman sale in 2017 relate to the buy side, not even the sell side where TDR was involved. So you can't use a hook of the opposing party in a later transaction as a jurisdictional hook for my client.
Thank you.
Thank you.
May it please the court, Joshua Slocum of Wilmeth, Marr and Deutsch on behalf of the respondent. I want to start by addressing kind of the main argument in their appeal, which is they claim that the allegations of an alter ego or a close enough relationship aren't enough to impose jurisdiction.
You're referring now to the form selection clause?
Correct, Your Honor.
That whether or not the form selection clause is controlling in this case?
Correct, Your Honor. And I would like to bring the court's attention to the case Horsehead Industries versus Metal Gesellschaft. We cite it on page 22 to 23 of our brief. It held that a parent company can be liable as a party to its subsidiary's contract if the parent's conduct manifests an intent to be bound by the contract, which intent is inferable from the parent's participation in the negotiation of the contract, we have that here, or if the subsidiary is a dummy for the parent, arguably we have that here, but the third one, or if the subsidiary is controlled by the parent for the parent's own purposes. And our complaint is replete with allegations that TDR controlled these subsidiary companies for its own purposes, made them act outside of their own
Even if we
interests.
accepted your argument that there was enough to pierce the corporate veil, why is that agreement related to the transaction that's being sued about here? Since it's very clear that this dispute is not about the initial purchase of the shares. There's no dispute that the plaintiffs got the shares, had the shares. The real complaint here is about the activity in 2017, which is not the agreement that was the subject of the form selection clause. So even if you won on that argument, where does that get you exactly?
Well, it gets me here, Your Honor, because the whole deal, when they were selling Target Logistics to TDR and its group of companies, is the TDR persuaded my clients, let's be partners. I will give you some cash, but you're also going to have shares, and you're going to share in the upside of this business venture. So what we have here is we have a claim for the breach of the implied covenant of good faith and fair dealing.
Isn't your argument about what happened in 2017, which had nothing to do with the initial agreement to purchase shares? It had to do with later activities that occurred once you were shareholders.
Correct, and we think those activities were malicious, and what they did is they deprived my clients of the value of those shares.
What do they have to do with the 2013 agreement, I guess?
Oh, okay. Well, let me move to the 2017 transactions. Let me point you to paragraph 82 of our complaint. We're talking about jurisdiction. It talks about meetings between TDR and the buyer in New York relating to these transactions. I can point out paragraph 89, which talks about more involvement.
When you, yeah, that seems very, very broad. What are you talking about? You say literally everything that you're complaining about happened outside of New York, correct?
No, that's not correct.
What happened that you are complaining about happened in New York?
Paragraph 82. This is the sale of William Scotsman, where TDR got a participation on the buy side, not just the sell side, but the buy side.
So the sale, you're saying the documents were signed in New York?
Yeah, meetings occurred in New York.
No, how many? No, okay. A couple of negotiations. You had New York lawyers. That's your big hook here. You have New York lawyers. And you had a New York bank. And maybe one or two meetings. But how many meetings occurred here as opposed to not here?
I don't know the answer to that
I
question.
think you do, because this is a forum nons issue.
Well, that's correct. It's also a pre-answer motion to dismiss.
Right,
So
but your client knows how many. Your client knows how many meetings.
Well, my client knows that the meetings that occurred in terms of the negotiation of the contract, where they were involved, there were multi-day meetings in New York. I believe there was also a meeting in Boston.
Weren't there meetings over a long period of time, over months?
They were. Well, the negotiations were. I wouldn't say the meeting. I don't know if the meetings.
Most of which did not take place in New York.
Well, they took place through the New York lawyers.
Can I just ask, how many of your claims require the application of foreign law?
Well, it's. I think the count is. I think there's.
Is it like 6 out of 9?
Yeah, but it's variations of the same abuse of right concept. So I mean, it's pled as a bunch of different counts. I wouldn't say that there's a great deal of difference between them, at least as I understand it.
Thank you. I'm sorry, do you have another question?
Yeah, but I mean, yes, it could be, but none of that, of 7 of 9 claims deal with different law than New York law, right? It may be the same law, but it's not New York law, right?
That's correct, Your Honor. We do have New York law claims, but there are some foreign law.
7 of 9 have, I think, are Luxembourg, right?
Well, yeah, we pled Luxembourg. We pled in the alternative claims under New York law. I think that when the factual record is fully developed, we'll have better sense of which law will apply.
Thank you.
Counsel, how do you respond to the argument that there were tons of meetings about this transaction occurring in New York, and for that reason, New York is just as good as a forum?
So I think there's two responses. First is the core allegations in the complaint about meetings in New York relate to the 2013 transaction, which is not what they're alleging caused the harm and is not really what the source of the analysis should be for forum nonconvenience. There is one paragraph in the complaint that points to a meeting in New York related to 2017.
That's what I thought. There was only one meeting in New York concerning the allegations but there were, and a New York bank and New York lawyers.
That's right. And interestingly enough, the meeting that they say happened in New York didn't involve their plaintiffs, didn't involve anyone from that, and this court has held in other cases that when the plaintiffs weren't even involved in the one single meeting, that's not enough to overcome the other factors in forum nonconvenience.
Can you speak to the claim on the alter ego claim? Was there enough allegations on his alter ego argument?
There's sort of two problems with the alter ego argument. The first, which I think is where your question goes, which is, did they plead enough to overcome that? And this court and the Court of Appeals have held that you have to show complete domination. That, I mean, the plaintiff's counsel used the word dummy, right? And here that's just not the case. William Scotsman, the entity that signed the agreement, had thousands of employees, tens of thousands of customers, had a headquarters in the United States while my client was in London. There's no allegations about commingling of assets or shared phone numbers or shared offices, any of the sort of hallmarks that we see. There's no piggy bank allegation. And importantly, between my clients and William Scotsman, the entity that they say is the dummy, sat other corporate entities that also had their own businesses that were active, functioning businesses. Briefly, the second problem with it is the Morris problem, which is you only get to alter ego if you have an underlying breach, and here there is no underlying breach, so it's not a free-floating claim. Thank you.